Warning, danger. I'm Joel, this is Jared. Welcome back to the Williams, ELLEBY HOWARD EASTER YouTube channel. Today we want to talk about cases and situations involving dangerous places, dangerous products, and then other products that may not be dangerous but warning labels are attached to them, because there are a certain category of cases we call failure to warn claims. And in my mind, some claims that people try to bring are complete BS. Some claims that people try to bring are absolutely legit, even though the media or the mainstream media may portray them in a way to make them seem frivolous. So what's the first thing you think about, Jared, when you think about a failure to warn claim?
I think the first thing I think about that most people don't realize is that if a company or a product maker gives a warning, it's presumed read by the people that buy or purchase the product. So I think it's important to point out early on that while some, stories get blown out of proportion, people think it's crazy to need to put a warning on something. Sometimes just simply putting it there doesn't take that much time or effort. And a lot of times, while it might seem stupid to need to put the warning out there, it's presumed read, so it's not that big of a burden on the company to do it, just in case there's someone that might not know or might need to know about, a potential hidden danger that could be presented by the use of a certain product or going to a certain place.
Yeah, the first thing I think about is when are warning labels appropriate and when are they actually needed and when is it overkill, right? Because if I go to the store and I buy a machete, if there's a warning label on it, I kind of laugh to myself, because I'm like, I would have to be a complete buffoon to not know that this machete is sharp, that it's dangerous. If I'm not careful with it, I could hurt myself or hurt somebody else, right? Yeah, go ahead.
Can I play devil's advocate here?
Yeah.
Because someone like you or I who grew up in a situation where there was a machete just at the house, you see someone use it, your frame of reference to what you should or shouldn't do with a machete is a lot different than someone who grew up in a country club neighborhood who had someone mowing their grass every day and then one day decided to move to the country and go buy a machete. They might buy that thinking that they can do X, Y, and Z with it, when in fact there are things that you probably shouldn't do with a machete. So, on its face, it might seem insane, but this is what raises the point, is yes, it seems that way, but I'll play devil's advocate and say, maybe you do need to know you can't chop down a tree with a machete.
If you're a lawyer watching this video and you have a failure to warn machete case,
call me.
Jared would want to be on, you would want Jared on your jury. Me, not so much. But regardless, all joking aside, I kind of look at it like warning labels are very important in situations where there is a hidden danger. And it could be a property that's got a hidden dangerous condition on it. It could be a product where the danger associated with that product is not obvious. And the number one thing I think about is what tort reformers or people who hate lawsuits use incorrectly as an example, and that's the hot coffee McDonald's case. The hot coffee McDonald's case in the media was portrayed completely wrong. The media says there was an old lady who bought a cup of coffee at McDonald's, who put it in her lap, who was fiddling with the cup or trying to drive at the same time and spilt it on herself and became a millionaire. Nothing could be further from the truth. In that case, McDonald's had coffee that was 190 degrees, which can cause third-degree burns in 3 seconds, even through clothing. Most restaurants have their coffee at 160 degrees, which would take 20 seconds in order for it to cause third-degree burns, which usually would allow the person who spills the coffee to get it off of themselves before they're severely hurt. Number two, the lady was not driving. Her grandson was driving. They were parked. She took the top off the lid to put cream and sugar in there, and it spilled and burned her body, over 16% of her body, including her genitals, badly. Number three, McDonald's knew that over 700 people had been burned by their exceedingly hot coffee prior to this lady getting burned. So they knew it was there. She didn't know that the coffee she was purchasing from McDonald's was dangerously hot until it was burning through her skin down to her muscle in her entire pelvic region. And 4, she tried to settle with McDonald's for her medical bills, which were around $20,000, and McDonald's offered her $800,000. 5, she went to trial. She got $200,000 in compensatory damages, which was then reduced to $160,000 for third-degree burns in the pelvic region because the jury assigned a percentage of fault to her. The jury awarded either $2 or $2.5 million in punitive damages, which was then reduced down to 4 something, I think, but reduced significantly because even though the jury found that McDonald's conduct was gross and exceeding ordinary negligence, the judge still reduced the verdict down. So what you heard in the media about this obvious hazard, not so much. And in those situations, like, that was a hidden hazard. It probably would not have happened if McDonald's had said, hey, our coffee is brewed 30 degrees hotter, and if it touches your skin, it'll cause third-degree burns in 3 seconds. Probably wouldn't have happened if they were telling their consumers that, but of course they're not going to tell their consumers that because people would hesitate to buy the coffee, right? So that's a hidden hazard, but the McDonald's made a conscious choice not to warn people of that because they knew people wouldn't buy their coffee. So warning labels in situations where there are hidden hazards on products, I think can be very beneficial. I remember I was working on a houseboat case one time where the exhaust of the carbon monoxide was coming through the back of the houseboat and it was congregating near the swim deck. And what happened is they would park the houseboat, they'd turn the engines off, the carbon monoxide would build up, people would jump in the water to swim. And what happens before you jump in the water and you know you're going underwater? You go, and you suck it all in. Well, carbon monoxide can cause you to pass out and drown and die. And that was happening to people. But they didn't know that there was a carbon monoxide buildup because the houseboat manufacturer chose not to warn about it, right? And so in situations like that where there is a hidden hazard, I think warning labels in failure to warn cases are very important. And when manufacturers make the right choice to warn about those hidden hazards, then they have a better argument that somebody was warned about it and chose nevertheless to encounter that hazard and they got hurt.
And it also allows for the consumers of a product to weigh the risk. In the houseboat situation, having a warrant, you can weigh the odds of, do you stop making the houseboat or do you make the houseboat and say, hey Joel, if you buy this houseboat, there's a chance this could happen. Mm-hmm. It allows the consumers a lot more freedom to contract and decide, well, okay, I'm willing to take that risk. There's a lot of products out there that are inherently dangerous, like fireworks, various things, and you can make a decision as to whether you want to engage in it knowing the risks or not. But it really, in today's society, makes no sense that if you as the houseboat manufacturer know that this risk is there and that people are dying, and then you just don't tell anyone about it. I mean, that's crazy. Anyone would want to know, hot coffee, whatever it is, you want to know what you're getting into when you commit to buying a product or, going to a certain property. And it's not, circling back to what I was saying earlier, it's not that much of a burden on the manufacturer to print it somewhere. I mean, they give you an owner's manual for almost everything you get nowadays and a way to register for a warranty and this and that and everything else. It's not that hard to just put a small warning in there about things that they know about.
Yep.
And I think you get into a different realm if you're trying to argue that they failed to warn of something that the manufacturer didn't know about. And that's totally different. But where it's blatantly obvious and the houseboat manufacturer, McDonald's, whoever's involved is on notice of these continued episodes happening, it's not that hard if they're going to continue to make the product and profit off of it that they could just include a warning.
Yeah, I would argue it's unreasonable for a manufacturer that's going to distribute and sell a product to the general public to expect everybody in the general public to be experts on that product. Because we have all purchased items that we had to go to YouTube and watch a video on how to properly use it, or go to an owner's manual. Heck, most product manufacturers nowadays, if there's assembly required, go ahead and film a YouTube video and put a QR code on there where you can scan it and learn how to properly install this thing. But they could put warnings there if they know about a danger associated with the product. They could put the warnings ideally on the product itself to warn against it if they know about it, right? But it also applies in premises liability or hazards on property situations, but really what it all comes back to is knowledge of the danger. So like if I go to a mine site and I see this enormous hole in the ground and I walk up to it and I fall in it, okay, that's on me. Like you should know that if you walk up to the edge of a ginormous pit and it's in plain sight, that you could get hurt. However, if there's a loose hand railing, or if there's an unstable shelf, or if there's something of that nature that is not obvious and you can't appreciate it just by looking at it, or if there's toxic fumes in the air and you can't smell them, right? But the property owner knows that they're there, then there should be some type of warning given to the people that are going to encounter that hazard so that they can then avoid that hazard until the property owner or occupier can get it fixed and make it safe again. And if the property owner or occupier chooses not to fix it or warn about it, well, then they might have to answer to personal injury lawyers like us, right? Because if they don't want to do the right thing for moral reasons, maybe they'll do the right thing for financial reasons. Or maybe they'll do like McDonald's did and try to take a situation that was absolutely their fault and they were absolutely in the wrong and try to take it out of context and sell it for some BS that it isn't really. I mean, that has proliferated our society so much that legit when I'm going through the jury selection process and I'm asking people, how do you feel about lawsuits and tort reform and all that? This happened in 1992. That's, God, 34 years ago. And people still raise their hand and say, well, hot coffee is a bunch of hogwash. They don't know the truth. Mm-hmm. So it is what it is, but warning labels can be appropriate and absolutely necessary in some situations. Yes, I believe in some products and some situations they're kind of silly and unnecessary, but when there's that hidden danger, then yeah, they're needed. So anything else on failure to warn or warning labels?
No, I think we've covered it. I do think that we might mention too that there's still kind of a negligence standard in terms of whether, how difficult it is or how practical it is to put a warning label on a product. I can't think of any offhand at the moment, but there are some products that just could pose dangers, but it's just difficult or impractical to put a warning label on them. So still at trial, it's not a black or white. You still get to weigh and apportion as far as whether it was reasonable, how the warning was put there, whether it could have been put in a place to warn. So it's not like there's just this strict liability on manufacturers that they have to do it or not. At the end of the day, having warning labels is just what our general tort system is based on anyway, which is a negligence standard.
Yeah, it really is not that complicated. It comes back to what did you know and what did you do about it? Did you act reasonably in response to the knowledge that you had? Was it reasonable to leave a warning label off when you have a known dangerous product or a hidden hazard? Or would it have been reasonable to put the warning label on there to warn people that they may encounter this hazard? So, but I think that's it for this week. We appreciate you watching the video and joining us for another episode of lawyers trying to make boring things sound interesting. But if this video has been helpful to you, hit that thumbs up, hit the subscribe button. Otherwise, we will see you next week. As personal injury lawyers, we love what we do, and we're happy to share the experience we've gained in personal injury law. To help our family, friends, and YouTube subscribers, we've shared over 300 personal injury videos covering various injury topics. So if you'd like to gain more knowledge that may help protect yourself or a loved one when they're on the roads or out in public, check out our channel or view our playlist of shorts for quick personal injury tips.